Hello viewers and students. This is Dr. Kashinath Neharkar, Assistant Professor, Sri Shivaji Law College, Parbhani. I welcome you in my YouTube channel, Law Education Volunteer Dr. Kashinath Neharkar, at lecture series on property laws. Friends, today we are going to discuss another important concept under Transfer of Property Act, that is notice. But before that, friends, please subscribe this channel and press bell icon to receive further notifications. So let me start today's lecture. Friends, notice is very important under transfer of property. Firstly, we must understand what is concept of notice. In general, say generally notice is given to give certain information. In a regular life, we get notice from government, we get information from government, we get information from various authorities through declarations, notices, etc. Then we can get the knowledge that the particular fact is there. The latest example relating to the notice or knowledge is the extension of lockdown up to 3rd May. So when such lockdown was declared, then it came to knowledge of everybody that lockout is extended to 3rd of May. So this is notice. So this is knowledge of everyone who is residing in India that the lockout is extended. So notice is nothing but the knowledge of fact. So the notice means knowledge or the information of fact. And where the person has a knowledge of any fact, he is said to have the notice of fact. So everybody have notice of particular fact. So friends, when it is established before the court of law that a person has a notice of some fact or the transaction, then such a knowledge is binding on him. And here we are discussing this concept in the context of transfer of property. So where the person is in the knowledge of any transaction which is called as a transfer of property under Transfer of Property Act, and when it is proved that the particular person has a knowledge of that transaction, then it is binding on that person. That person cannot deny in court of law. So he cannot deny the knowledge of such fact if it goes against him. So whether that knowledge is beneficial to him or not, he has to accept. He cannot deny it. So, because that particular thing was in the notice of that person. That person was in the knowledge of particular fact. So the notice may be of two kinds. The notice may be actual notice, or the notice may be the constructive notice also. We must see what are these two notices, but before that we must see what is the definition of notice under section 3 of Act. And accordingly, section 3 of the Act defines notice as, and while defining the notice, section 3 of that gives the circumstances when it is construed that person have a notice of particular fact. It is interpreted when that particular person is found in a certain circumstances and within the knowledge of particular fact, then it is construed that the person has a notice. So firstly go through the definition. See, so person is said to have notice of fact. Person is said to have notice of fact when he actually knows the fact. See, as before this definition I have told you that notice may be of two kind. It can be actual notice or it can be constructive notice, and both of these kinds are covered by this definition. So so you should go through the definition. If you go minutely through this definition, you can understand these two kinds of notices. So the person is said to have notice of fact when he actually knows that fact, this is the actual notice, or when but for willful abstention from inquiry or search which he ought to have made, or gross negligence he would have known it. This second part of definition is the constructive notice. So these are the circumstances when it is presumed that the person have a knowledge of fact. See, now we must see this notice in detail. You should understand what the actual notice is. Firstly, we are going to discuss what is actual notice. Friends, actual notice means direct or express knowledge or the information about something. So the actual knowledge is a matter of fact. So the direct knowledge is necessary to person. So how the person gets direct knowledge? See, firstly, when the person is directly connected to particular fact, it means that fact is directly known to him. So there is direct connection. So when person receives the knowledge directly from that happening of fact, that is also one kind of actual notice. So when that person gets knowledge through his eyes, through his ears, so what the senses of perceiving the knowledge, so such knowledge is called as actual knowledge. So it is a matter of fact. When any fact happens before the person gets the knowledge, whether he want to know it or not, he gets the knowledge. So it is a matter of fact. So we must see what are the essential of this kind. See, first essential of this kind is the information or knowledge must be definite and it should not be rumor. So when that person gets knowledge and when it is to be considered as an actual notice, it should be fact. Rumorous things cannot be called as the knowledge of that person. That person, if at particular point or on particular place any accident happens, and at that time if that person was present at the time of happening accident, what happened in front of him, that is his actual knowledge. That is his actual knowledge. So it is the fact, it is matter of fact. But if that person was not present at that place, but he heard something about the accident which was happened somewhere else, then what the knowledge of that person, it is the rumor. So it cannot be called as his actual notice. Then secondly, only knowledge of parties interested into transaction is called as a actual knowledge, and it is regarded as a knowledge. So we must see this actual notice in the context of transfer of property. So the knowledge of parties to that transaction is called as a knowledge. Secondly, only knowledge of parties which are concerned or which are connected to that transaction can be called as actual notice, because party, they know what the transaction they are doing, what the transaction they are entering, how they are completing, what are the terms and conditions of the transaction. That transaction is known to parties themselves. So, and the knowledge of outsiders regarding the transaction between such parties cannot be called as actual knowledge. Then third is the knowledge must be related to transaction in a question. Third, it is very important that when a particular notice, a particular knowledge of particular transaction can be called as actual knowledge when there is a dispute relating to existence of particular transaction or not, whether parties enter, if the dispute is related to whether parties enter into the transaction or not. In such dispute, the knowledge of each party, knowledge of attesting parties, can be called as actual notice. So the knowledge which is not relevant cannot be taken as the actual notice of such transaction. So this is the first kind of notice. Now friends, we must see a second type of notice, or second kind of notice, which is called as a constructive notice. Friends, this is also called as a presumptive notice, because court presumes that person should have the knowledge of fact. The person who is before the court, that person should have knowledge of that fact. So it is a presumption, it is a legal presumption. As you know, in law there are many provisions, even there is a law of evidence also, there is a IPC also, that provides some legal presumption. And when a particular thing, a particular fact happens in a particular circumstances, then it is presumed that person should have knowledge of it. So apart from that, we must say what is the constructive notice. See, the constructive notice is based upon equity. This is the principle of justice. So where in constructive notice, the person actually does not know anything about the fact. He do not know anything about the fact, but under certain circumstances court treats that he must have knowledge of fact, and such a notice is called as a constructive notice. Such notice is called as a constructive notice. For example, see, let me take the current example. See, the law of land. Everybody know what is the law of land, and everybody should know what is law of land. Whether it is criminal law, it is civil law, whatever the thing is that. See, if and as you know, there is a principle in IPC, that is, ignorance of fact is excusable, but ignorance of law is not excusable, because you should know the law of land, because it is a constructive notice. So when you are in India, when you live in India, you must know the laws of India. So in such a circumstance, court presumes that you should know that. So currently, as you know, now there are many prohibitions imposed by a government to prevent the spreading of corona. So what the prohibitions that are imposed by government on the rights of civilians, citizens, that should be known by everybody. So under such circumstances, nobody can say that the government have not informed me specifically. Under these circumstances, so such a knowledge is called as a constructive notice. See, friends, it is a legal presumption. So the circumstances in which court presumes that a fact is a constructive notice, so the court interprets that under such circumstances that person should know the thing. So which are those facts which you should know? Number one, when a willful abstention from inquiry or search. See, whatever the thing you are doing, it is your responsibility to inquire about what is fact. So for example, when a person avoids to take the notice or denying the acceptance of registered envelope with proper address, it means it is your willful abstention from getting knowledge of fact, because you are denying it. Else, if you have accepted it, you should have got the knowledge of that. So it is also in such circumstance also, whether you accepted it or not, the court presumes that you have knowledge of the fact that is mentioned in that notice or the RPD. Then second thing is the gross negligence. When you have committed gross negligence in getting the knowledge, in getting the information in such circumstances also. So what is gross negligence? See, while doing anything, any act, you should act like the prudent person, because prudent person, he inquires about the thing. See, so you should take all the precautions, you should take all reasonable care while doing anything that is relating to transfer of property here also. So this is also, if you fail to do that, then that will be called as a gross negligence. So friends, these are the two kinds of notices. Here we discuss what is a notice, and secondly the two kinds of notice, actual notice and constructive notice. The notice is nothing but the knowledge of fact. When a notice, when a knowledge is brought into the notice of that person, when a particular fact is brought into the knowledge of particular person, then it is called that person have notice of particular knowledge. Secondly, the actual notice, when a person gets direct information from the fact happening of any fact, that is called as a direct notice. And constructive notice is nothing but it is the legal presumption, and when the court presumes that you are under obligation to inquire or to get the knowledge of particular fact, then it is immaterial whether you have actually inquired it or not. It is immaterial, and court presumes that you have legal knowledge, and that is binding upon you. So friends, if you like this video, please like it, share it with your friends, and do not forget to subscribe this channel. Thank you friends.